Go ahead, Ann.
Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention. Court is now sitting. God save the United States and this honorable court. Case number 19-3088, United States of America versus Gregory C. Cook, appellant. Mr. Zucker for the appellant, Mr. Hansford for the appellate. Mr. Zucker is now unmuted.
Good morning, Mr. Zucker.
Morning, Judge. May I begin?
Sure, please.
Okay. Morning. May it please the court, John Zucker on behalf of the appellant. 5 minutes for rebuttal, please. The issue here before us is a recurring one in drug cases, and it almost doesn't matter whether it's a possession with intent to distribute or a conspiracy, both of which were at play in this case. And the issue is comes about frequently in cases where the evidence is all circumstantial, and the issue that is recurring is where do we draw the line between justifiable inferences and speculation? And that's what this case comes down to, as have many of the other cases. Now, there's no direct evidence that Mr. Cook ever possessed any cocaine or heroin or any other contraband in this case. There's no evidence that he ever distributed any, and there's no overt evidence or direct evidence that he conspired with the co-defendant to commit this offense. The government is essentially trying to cobble together a bunch of disparate pieces of circumstantial evidence connecting him with the co-defendant and hoping that the amalgamation of all that circumstantial evidence creates sufficient evidence from which the inference that they seek can be drawn. And I suggest to the court that what they're relying on here is essentially a lot of disparate evidence, and that is speculative to confer or to infer in this case, as with all due respect to Judge Boasberg, as he did, that Mr. Cook was part of this conspiracy, or that he had the ability to exercise dominion and control over the drugs that were never in his possession.
Are you contending that our case law, that there's no difference between direct and circumstantial evidence, is that that's not the law, or that
no, that's no.
Dependent that?
No, that's clearly the law. That's clearly the law. A case can be based on circumstantial evidence, and circumstantial evidence is entitled to the weight that the evidence warrants based on what the circumstances are. But in this case, there was no evidence. I mean, the judge said that the most logical inference is that in response to the call, Mr. Cook collected the drugs and the guns and the cash inside the apartment, put them into a pack, and had the minor child leave with them. Well, that's possible. It's possible that did occur, but there's no evidence supporting that proposition that in fact is what occurred. The child was never called. There's no indication that Cook ever touched anything in the bag. There's no physical evidence connecting him with the bag. It is, in this case, pure speculation to believe that is what occurred.
Can I ask a procedural question?
Sure.
There was a Pinkerton instruction given with respect to all three of the possession with intent to distribute counts. And you don't challenge that instruction.
That was certainly not part of our brief. I frankly do not even recall that at this point. I mean, I take your word for it, but I don't recall it.
Yeah, it's at the 688 and 89 of the separate appendix. So if indeed we disagree with you and hold that there was sufficient evidence of a conspiracy, doesn't that mean necessarily that there was sufficient evidence for the three possession with intent to distribute counts?
If there was a sufficient basis to conclude there was a conspiracy, does that ipso facto mean that he's guilty of the possession with intent to distribute? I mean, I guess it would determine what the scope of that conspiracy was as a practical matter. Considering that there was no evidence that there was any agreement between them, the agreement is all being inferred from conduct.
Well, what I'm saying is that the jury was instructed that they could find possession with intent to distribute based on the Pinkerton theory, and which is that each member of the conspiracy is responsible for crimes committed by the other members as long as those crimes were committed to help further or achieve the objective of the conspiracy and were reasonably foreseeable as a necessary or natural consequence of the agreement. That's at SA 688, and the similar language appears on the verdict form for the possession counts, well, particularly for the possession count for the cocaine, possession with intent to distribute cocaine base of 28 grams or more. And so what I'm saying to you is that the jury had before it the Pinkerton theory, and if we find that the evidence of conspiracy was sufficient, then isn't necessarily sufficient then for the possession with intent to distribute counts? Is there some argument that it wouldn't be? Hit it in your briefs.
I guess my response off the top of my head is it would depend what you found the conspiratorial agreement was. If you found that, for instance, the conspiratorial agreement applied to that only which was within the backpack, then that would exclude the possession with intent to distribute for the drugs that were made in the house that were not placed in the backpack. Did that answer the question?
Well, I'm not sure that it did, but I don't want to monopolize the time further with it.
But I suggest that there is simply no evidence to indicate that Mr. Cook exercised dominion and control over any of the contraband in this case that was recovered, and that was the basis for these charges. And I think what we have here is analogous to the situation in Ziegler, where at the close of the government's case there was not sufficient evidence, and it should have never gone to the jury, but that evidentiary gap was filled in, and certainly the government is allowed to rely upon evidence that is introduced by the defense. But in this case, I think what happened is very similar to what happened in the Ziegler case, where the defendant put on a defense that was not credited, and the jury drew adverse inferences to fill in the gaps in the government's case because they did not credit the co-defendant witness, who was clearly trying to exculpate Mr. Cook, as she had done from the beginning. When the case first came in, and at the preliminary hearing, she went to the prosecutor and said he didn't have anything to do with it, the drugs are all mine. And she testified to that throughout. It was clear the jury didn't credit her on that, but that's where the missing gaps in the evidence came from the impermissible drawing of a adverse inference. My time is up.
Yeah, you're into your rebuttal time, so if my colleagues have no further questions, we'll hear from the government.
Good morning, Your Honor, and may it please the Court, Eric Hansford for the United States. We think Appellant's arguments here ignore two basic requirements of sufficiency review. First, you must view the evidence in the light most favorable to the government, and second, you have to look at all of the evidence in the case, not the evidence piece by piece. And the evidence as a whole here does strongly support a conclusion that the defendant was working together with Rice to distribute drugs. You've got the phone call when Rice is stopped by the police, where the person who she decides to call at that point is the defendant. And then the defendant seems to help Dante, her son, get out of the apartment with a backpack full of drugs and money, and then lies to the police afterwards, moments later, when they ask about the child's whereabouts. And you've got the recorded jail phone call where the defendant is discussing knowledge about the case that only an insider would know. And then you've also got the fact that there's a bag of evidence recovered at the Waldorf house, which is a drug-encrusted Pyrex. That's the defendant's house in Waldorf, a drug-encrusted Pyrex, Cornelia Rice's old school bus driver ID, and a commercial money counter. And related to the commercial money counter, you've got unexplained wealth of the defendant, particularly thousands of dollars of unexplained cash deposits. And there's reason to think that's linked to the apartment, given that his ATM card for that account is found in the apartment, and he's using the ATM that's closest to the apartment. And then you've got his general ties to this apartment where there's drugs out in the open. He's got a key. He's free to come and go. And so based on all of that, we do think there's sufficient evidence here. We think it's similar in many ways to the evidence that this court went through or the types of evidence that this court went through in Gaskins that's typical in a drug conspiracy that was found lacking in Gaskins, but is present here. And we think it's similar in many ways to the evidence found sufficient in Childress. In terms of circumstantial evidence, of course, circumstantial evidence is just as valid as direct evidence. The jury was instructed as to that. We do think there's direct evidence in this case, in particular the recorded phone call from the jail and the bag of contraband found in the Waldorf house. But even if that is all considered circumstantial evidence, we do think that's just as valid. And then just on the backpack.
Can you name a case where we or any court has found sufficient evidence of a conspiracy for a person who was never found in possession of any drugs themselves and never participated in, there's no evidence that they participated in a transaction themselves?
I think that may map on to the Childress case. Certainly the defendant there was not found in possession of any drugs. I do not recall at this point if she may have acted as a go-between in that case. So I don't have a case maybe exactly on those facts, but I think that it is reasonable to infer that the defendant here was in possession of the drugs that were in the backpack. And so you can draw circumstantially, whether or not there's direct evidence of that, you can find circumstantially that he was in possession of the drugs. And I don't think
But
that's
to find him guilty of possession with intent to distribute 28 grams or more, we have to either hold him accountable for the 14 plus grams that were in Miss Rice's bra, or the cocaine cookie that was underneath a dumbbell in the bedroom and not in plain view.
Well, I think there's all of the, I believe there was something like 32 grams of crack cocaine found in the backpack itself.
So there was more than 28 grams in the backpack?
I believe that's correct. I would also, I'm thinking based on your prior question, yeah, I think there were 34 grams in the backpack. But based on your prior question, the Supreme Court's decision in Ocasio said that in a drug conspiracy case, it's dicta, but the Supreme Court said in a drug conspiracy case, there need not be direct evidence, or there need not be evidence that the defendant ever agreed to distribute drugs. It's enough if he was storing the drugs. So I think that is a situation where the court is recognizing that in a conspiracy, in order to be convicted based on a conspiracy, you don't need to actually take all of the steps of the underlying crime. You just need to agree to help someone else commit the crime. And I think that is what we have here. And just in terms of the backpack and what Judge Boasberg said about the backpack, whether or not the defendant is actually the one who packed up the backpack is not the relevant question. The question is whether he is helping Dante escape with the backpack full of drugs and understanding what's in there. And we do think there's circumstantial evidence of that, given that he's shortly before Dante emerges, poking out his head and noticing the police. And then right after Dante has left, he's lying to the police about Dante's whereabouts.
Suppose we're concerned about a situation where you could have, someone who is a roommate of or a housemate a drug dealer, and they know that that's what's going on. They have no involvement in it, but that's where they live, and they're, for whatever reason, stuck living there. They've got a key. They come and go. They have an association with the drug dealer. What if we're concerned about opening the possibility of liability or conspiracy for people like that?
I think it's clear under this court's case law that that would not be enough. Simply knowing or being in the presence of drugs would not be enough to convict someone of conspiracy. I think that the jury was appropriately instructed that simply being in the near presence of the drugs was not enough to find the defendant guilty of possessing the drugs. And so, but I think that's ultimately, in many of those cases like that, in that scenario, often...
So if you have that situation and the roommate gets a call from the drug dealer saying, I'm with the police, and they say, oh, you're with the police, okay, well, I'll come check on you, and then the drug dealer's son or accomplice hears that and decides to leave with drugs, you would say we would infer that they caused them to leave with the drugs, or that shows that they're part of the conspiracy, even if they could be leaving because they know that there's drugs in the house, and if the police might come there, they need to get them out of the house.
I don't think we certainly would not say that. I think we would say it's a jury question what the defendant is thinking at that point, but we would not say that the innocent roommate who gets a call and is told to leave, who knows about the drugs.
Well, you would think the night most favorable to the government, you could infer that they told the person to leave because they're part of the conspiracy.
Well, no, I mean, I think that the evidence here that is what the defendant was doing is stronger, because shortly before he peeks out the door and looks for the police, takes special note of the police, and then right afterwards lies to the police about where the child has gone. Plus, there's all of this other evidence. But I think that
he can lie because he knows that the kid took drugs with him, and he doesn't want the kid to get in trouble and end up in foster care.
So I think those are entirely permissible jury arguments to be made, and I think they were made in this case. But I think once the jury has made the decision, has rejected that is what the defendant's doing, and has found instead that what the defendant is doing is intentionally helping, because he has agreed to help distribute the drugs and possess with intent to distribute. I think on appeal, this court has to defer to that finding of the jury on that sort of factual scenario. I fully agree that there is a triable jury question in that case. It's just not a situation where on that evidence you'd be overturning it on appeal. And so if there are no further questions, we would ask this court to affirm.
Thank you.
May I proceed, Judge?
Yes, go ahead.
Okay.
Mr.
Turning first to the Childress case, I think with all due deference to the prosecutor, his recollection is somewhat mistaken. In Childress, that was the Rachel Edmonds case, and it was one of the relatives, also named Edmonds, who that issue came up. And the evidence showed in that case that not afterwards, but during the course of the conspiracy, there were recorded calls where that person was discussing drugs, avoiding the police, introducing couriers, accepting money when her significant other, boyfriend, wasn't around, who was the principal. There was much more than there is in this case. So I think that case points exactly in favor of the defense, that because the conversation after the fact was after the fact, it was, and it's unfair to hold it against the defendant that because he knows of the activities of the principal, of Miss Rice, Therefore, he has to be inferred, and it's reasonable or has to be inferred that he is a participant. There simply is no basis to draw that conclusion. Regarding the cash deposits, the amounts involved in this case were not, the pattern that the officer testified to was that before the mortgage payment of $900 and change was due, there were frequently cash deposits to cover that mortgage. I would say that in and of itself does not establish and is not consistent with the type of cash that we see in a drug distribution ring. It's somebody who's dealing with cash. As the officers acknowledged, there are people who do. Regarding the government places great reliance on this claim that Mr. Cook went to the door prior to Dante's leaving. Interestingly, whatever occurred at the door, the officer didn't think it was significant enough to note or broadcast about until after the arrest of Mr. Cook, and the officer sitting next to him contradicted, Hashida contradicted, who had the same view. He says, from where we were seeing, the door was closed, we couldn't see the person's face, the lighting wasn't good enough. So I'd say the court should have some concern about the exaggerations with the other officer. Regarding the evidence that is recovered from Waldorf, I'm not sure how far that gets us. It's a house in Waldorf. The defendant owned the house, but his brother lived there, and his brother had a record, and his brother, they found his brother's Bureau of Prisons identification there. It's clear that Mr. Cook couldn't have been there for at least a week because he was incarcerated. So how is what's there attributable to him when he hasn't been there? And there's no evidence when he was there last. There's no evidence linking him to any of the contraband that was recovered. The contraband that was recovered had Miss Rice's ID in it, and she says that she was being evicted, so she had personal property removed and stored at Mr. Cook's house. I see my time is up. Are there any other questions?
I don't think so. I don't hear any. Mr. Zucker, you were appointed by the court to represent Mr. Cook, and we are grateful to you for your assistance.
Thank you.
But thank you both. The case is submitted.
Do I have to do anything?
Case number 20-5286, Shawnee Tribe Appellant versus Stephen T. Mnuchin in his official capacity as Secretary of the United States Department of the Treasury, et al. Ms. Thomas for the appellant, Mr. Bohan for the appellate. Ms. Thomas is now unmuted.
Good morning.
Good morning, Your Honors. And may it please the Court. Pilar Thomas, on behalf of the Shawnee Tribe, a federally recognized Indian tribe with over 3,000 tribal members, located in Oklahoma, a state with one of the worst COVID-19 outbreaks in the country. Your Honors, I'd like to make 3 points today here about the government's position and the lower court's decision that supports that position, that the government can, without any judicial review, use objectively and patently false data, the result of which flies in the face of the law's express intent. First, the government's use of objectively false data that has the tribe with a population of 0 is legally and factually impossible, by definition arbitrary and capricious, and the result is absurd and contrary to law. This federal determination, unbounded by actual facts or the record before them, is reviewable under the APA.
Let's assume we agree with you that it's reviewable. I'm trying to understand your claim. The government says that it attempted to ascertain the population for each tribe in the formula area as defined by the Indian Housing Block Grant Program, correct?
Yes, Your Honor.
You don't allege that you had enrolled population inside your formula area, do you?
Well, Your Honor, the tribe does not have a formula area.
I'm sorry, there was a little bit of a pause in my video. Perhaps others got it. Could you repeat your answer?
Zero population.
Ms. Thomas, you're freezing up on me. I don't know if the other
Can you hear me?
panelists are having a problem.
Yeah, me too.
Yeah, we had a temporary disruption in our internet. I apologize, Your Honor. So to finish answering the question, the tribe doesn't have a formula area. It doesn't participate in the Indian Housing Block Grant Program. And the Indian Housing Block Grant Program formula, at the heart of it, is a census-based formula, which, as we make in our complaint, is first of all race-based. It's not based on actual tribal enrollment population data. It's based on the census form, somebody checking whether they are of American Indian or Alaska Native descent, which is not the same as a tribal-based population. Secondly, the tribe doesn't have a census tract, so it will have zero population under the census, and that's why it has a zero population under the IHBG formula. And in our,
there were 3 tribes that the government said did not participate in the IHBG program, but the government basically ascertained, this is at the supplemental appendix at 103, that they ascertained what population could be attributed to their defined formula areas, the Chicken Ranch, Mohegan, Prairie Island. Are you alleging that something like that could have been done for your client, but it wasn't?
Yes, Your Honor. In fact, that's the point we made in the lower court as well, that once the government used the IHBG formula and saw that not only for Shawnee Tribe, but in fact for 24 other tribes, it had a zero population in the column that the government looked at, that the government had at least 2 and maybe even 3 other pieces of data. If you look at the formula itself, which we have in our appendix, you go 4 columns over, there's a column that says HUD enrollment, and that's a number that the tribe provided to HUD with their enrollment numbers a few years ago, so it's only 2,111. The government asked the tribes in April to submit certified documentation, including the certification under penalty of perjury of their tribal enrollment data.
Okay, I don't want to cut you off, but I want you to answer my question specifically. My question specifically is that they said that for these 3 tribes at SA 103, they found out what their formula area was, and then they got data for the population of the tribes in the formula area. You answered me earlier by saying you didn't have a formula area. So I'm trying to understand that answer and how that relates to what occurred for these other tribes that didn't participate in the IHBG program.
So as we understand from the government's position, as stated in their May 5th announcement, is what I believe you're referring to, Your Honor, they acknowledged that there were several tribes, 3 tribes that are not even in the IHBG program on the formula grant. And so they had to consult other information, and they received other data from HUD. They don't say whether that data was based on a jurisdictional area or a formula area. The government, in its own documentation, says it asked HUD for the information. It could have done the same thing here, but it didn't. The government could have consulted with the BIA, who also had enrollment data on the tribe, but it didn't do that either. Or the government could have consulted with the certification document that the tribe submitted under penalty of perjury to see what the actual number was. But it didn't do that either. So instead, it used a obviously false piece of data to award the tribe $100,000. instead of its fair share, something closer to the 3,000 population that the tribe actually has. And so that is part of the arbitrary and capricious nature of the government's action here. It had alternative data that was arguably in fact, factually more reliable than the zero population that the government used instead to make the award.
Ms. Thomas, were you done with that, Judge Wilkins?
Yes, Your Honor.
Yes.
You were? Okay. I just have two quick questions for you. In a footnote in your blue brief, you make an argument that the funds here are not a lump sum appropriation, but rather a line item. Did you make that argument in the district court?
We did not, Your Honor. We pointed out, though, that the lump sum appropriation falls outside of the purview of V-Hill.
Wait, I thought you said it wasn't a lump sum, that it's a line item.
Well, our argument below was that this particular appropriation falls outside of V-Hill, and we support that further by pointing out that this arguably is not even a lump sum distribution, that in fact it's a line item distribution, and we cite to the General Accounting Office's definition.
Yeah, but you didn't argue this, and is there a particular reason why you buried this in a footnote?
No, Your Honor, other than to alert the court to the fact that there's an alternative explanation for why the V-Hill case should apply here.
Your argument, then, I take it, is that even if this is a lump sum, that the language of the statute about basing the distribution of funds on tribal expenditures is enough of a standard. That's your argument, right?
Yes, Your Honor.
Okay.
In fact, even if
is this, you say in one point in your brief that the government used participation in the IHBG program itself, participation in the program, as a prerequisite for receiving title fund funding. You say that at page 10. Is that, in fact, what happened? Do you have any? I mean, I couldn't find anything in the record that said that participation in that program was a prerequisite for the money.
Your Honor, the inference is that instead of using the tribe's reported and population number, the government, in which they asked every tribe to submit, instead of...
I understand that. I understand that's not what I was asking you. I get that argument, but I thought at page 10 you actually say that the money was distributed on the basis of the tribal participation in the IHBG program. But that's not accurate, is it?
Well, it isn't, in fact, Your Honor, the result, because the Shawnee Tribe...
Yeah, okay, I understand your point. Okay.
And I see my time up here.
Unless my colleagues have any other questions, we'll hear from the government.
Good morning, and may it please the court. Thomas Pullum for the Appellees. The CARES Act tasked the Secretary of the Treasury with distributing $150 billion in assistance to state, local, and tribal governments within 30 days. For some governmental units, the Act provided detailed instructions about how the amount of assistance should be determined. For tribal governments, however, Congress provided only general guidance and directed that the specific amounts would be determined by the Secretary in a manner that the Secretary determines appropriate.
Excuse me. Yeah, of that sentence. It's not determined by the Secretary. It's based on increased expenditures. You would be totally right about this if the statute said what you just said, that the money shall be distributed on the basis of standards adopted by the Secretary. But that's not what it says. It says based on increased expenditures as determined by the Secretary. Let's just get to the core of this case. Why isn't that sufficient statutory evidence of both that this is judicial, that this is judicially reviewable, and that we have an adequate standard here? I mean, even if, let me just finish my question. I mean, even if, as you say in the brief, that the Secretary's decision the Secretary's decision to use population data is not reviewable. Certainly, that population data must in fact be a proxy for expenditures, increased expenditures.
Certainly. So I think when we look at the statutory language, it says that the amount that a tribe receives shall be the amount the Secretary shall determine that is based on increased expenditures and determined in such manner as the Secretary determines appropriate. So this reference to increased expenditures is kind of nestled within the Secretary's determination. And this court has said repeatedly that when we have...
Does the Secretary have the discretion not to base it on increased expenditures?
Well, I think it's an instruction to the Secretary, but it's the Secretary's determination whether this number is based on increased expenditures, and that's the language I think is comparable to cases like Webster and Drake and Claybrook that invoke more of a subjective standard rather than an objective standard.
But in Drake, there's no standard. The only standard in Drake was, as the agency decided, it didn't say based on anything. It was just the Secretary should decide, and we said that was very important in Drake. That was one of the facts, and of course Drake was a prosecutorial discretion case.
So we could look at some of the other cases. Claybrook, for example, provided that an official could adjourn a hearing if the official determines that it was in the public interest.
Right. So yes. If this one said that the Secretary could distribute as the Secretary determines in the public interest, that's a standard for which there are no standards.
But the court's
this case says.
The court's analysis there wasn't based on the public interest. It said all we have to review is the official's determination of whether it was in the public interest, and it was that determination that made the difference, not the public interest standard. That's what this court said.
Well, the court said, I'm going to quote, adjourning a meeting in, quote, in the public interest is the kind of decision that resists judicial review. So I don't think you're right that it's irrelevant that this was a public interest standard.
Well, so, I mean, even if that part were could provide some kind of hook for review, as the district court said, that kind of, that's not the challenge that the tribe actually brought here. They're challenging the manner in which the Secretary calculated these amounts.
I don't think that's accurate. Their argument, the Secretary's position is that population data is an adequate proxy for increased expenditures. The tribe's argument is that it isn't.
Well, I don't, with respect...
Isn't, and it isn't because it isn't for this tribe, because the data said it had zero. It isn't for the amicus, because the Secretary's data said it had zero. And it isn't for we went through the list, there's at least 10 other tribes that came up zero in it. So their argument goes directly to the Secretary's rationale for using the IHBG data. The Secretary said it was a proxy. The tribe says, no, it's not a proxy because it and other tribes came up zero, even though they have significant populations. That's their argument.
So a couple of points here. One, this reference to increased expenditures, I mean, that itself is something that that's not an objective independent fact that's directly ascertainable. These are numbers that weren't known because the time period hadn't run yet, and they are in fact affected by the Secretary's determination, because how much a tribe spends will be...
We all accept that, and that's why the Secretary said it needed a proxy, right?
Yes, so maybe I'll walk through what the Secretary said here. He said, as Your Honor indicated, by necessity and statutory design, there has to be an estimate. I'm focusing on expenditures that are specifically related to the public health emergency, and population corresponds with those types of expenditures, such as increased costs for medical and public health needs. And then the Secretary specifically chose a population measure that is a measure of what's called the tribe's formula area, which is the area of the tribal government's jurisdiction and other areas where the tribal government provides services, with adjustments for overlapping.
Yeah, I've read all that. I understand all that. Suppose the IHBG data here, suppose the results of it were totally random. In other words, suppose for whatever reason it had absolutely no relationship to expenditures, and the funds got distributed based on that. Would that not be reviewable by this court?
Well, I don't think so, for reasons the district court laid out, because I think that goes to the manner. But even if so, I think we could look at.
Just let me finish my question. So you're telling me that if the population data produced random results, that is, the money was distributed with no reference to the increased expenditure. In other words, it was in fact not based on increased expenditures. I use the word from the statute, based on. It would not be reviewable? That's your position?
Well, I don't think we need to actually get that far, because I don't think there's any real dispute that this population measure, in fact, covers increased expenditures.
That's the merits question. That's not the reviewability question. Now you're talking about the merits question.
Well, so we perhaps this court's decision in Milk Train would be helpful there. In that case, the statute said that assistance, a similar type of assistance, would be distributed in a manner determined appropriate by the Secretary to compensate for a certain year losses. The Secretary there set a limit on eligible production levels so that no assistance for losses above those levels would be provided. The court said we can't review that because the statute left it to the Secretary's discretion how to distribute those funds. The court didn't kind of ask whether the limit was unreasonable or had no relationship to losses. It said that's something the statute puts aside. Similarly here.
Out the whole second half of Milk Train, which is that the court said that it could review whether the Secretary compensated the milk producers for economic losses that occurred in 1999 rather than in prior years.
That's
and that wasn't. We didn't find there that was unreviewable because it was kind of part and parcel of the ultimate discretionary decision. We said that the discretionary decision had to be based on that factor. So why isn't that exactly what we have here?
Well, that's right. And the court undertook a very limited review just to assess that the Secretary was there looking at the right thing, aiming at trying to calculate.
It may not be that there's very much review, but there was review. And you're arguing that there is no review here. So why doesn't Milk Train sink your argument?
I think it doesn't for the type of challenge that the tribe has brought, which is analogous to the kind of production limit challenge in Milk Train rather than the kind of purposive challenge in Milk Train. But you know, even if we're wrong on reviewability, the Secretary's decision document laid out in the May 5th announcement and the FAQs establish a clear relationship between the increased expenditures and the specific population.
Are you saying that we should go ahead and go to the merits? I thought you said that if we find reviewability, we should remand.
I do think, I mean, that would be I agree, that is the normal course that this court says it should follow, would follow and should follow here. I was just trying to address if you had questions about that. But yes, the normal course when a district court issues an injunction on a basis that this court, or denies an injunction on a basis that this court finds an abuse of discretion or involving legal error, is to remand back to the district court for the discretionary weighing of the factors, and that is what this court should do.
Let me ask you this. Two questions. One related to this point. One of your arguments in your brief for why this court should not address the merits is that the record isn't before the district court, right? We don't have the record, but we have the May 5th announcement. We have the data, the IHBG data spreadsheets, and we have this June 4th frequently asked questions, and the latter document basically answers every question. It says, it explains why the secretary selected the data system it did. It explained why it didn't use other data. It explained how it handled tribes who didn't show up in the database. What more do we need to decide this case? At a minimum, what more do we need to decide at least the preliminary injunction question?
So I don't think you need anything more to decide the preliminary injunction question. You could do that on the same basis for what was before the district court. Okay. And I agree that these documents lay out an adequate rationale. I think our argument was that if you were going to, if you needed to engage in a kind of searching inquiry to what the secretary had before him, that would normally be done on the basis of the administrative record.
I understand that. I understand that point. But speaking of the preliminary injunction, the district court, am I right about this? Just tell me if I'm right. The district court seemed to have accepted that there was irreparable injury, but that the tribe wouldn't succeed on the merits. You're not challenging the irreparable injury issue here, right?
That's correct.
Okay. And my last question is going back to our discussion earlier. Okay, so, we have to, when we interpret a statute, we have to give meaning to all of its words. So what, in your view of the statute, do you think the phrase is based on increased expenditures of ... What role does that language play in the statute?
I think that's telling the secretary what he should base his determination of the amount paid. It should have a relationship to increased expenditures.
And say once more then why that isn't a sufficient limitation in the statute to make the secretary's ultimate decision reviewable?
I think,
without telling me about the merits.
I think because it's nested in the secretary's determination, the secretary is determining what the increased expenditures are in a manner that he determines appropriate. And I think this brings up that kind of subjective standard of the type that I said at issue in Webster and Claybrook. CC Distributors is another one where the Secretary of Defense there had to determine whether something must be done by the military. And this court says the statute doesn't provide a reference point for us to look at. The only statutory reference would be the Secretary's determination. And so it's that kind of distancing, having it be based on the Secretary's determination in combination with kind of a whole set of factors about this. The case law tells us to look at the type of administrative action we have, the statutory structure, and kind of the overall scheme. Here we have a structure that gave very detailed instructions for one part, few instructions for another. It's distribution of a set amount of funds over a limited period of time with an instruction that all of the funds have to be distributed. So the Secretary can't just do one at a time. It has to be done kind of comprehensively. And we think all these facts suggest that this is unsuitable for judicial review.
Mr. Plum, thank you.
I have some further.
We've got some more questions here. Go ahead.
So I have three questions for you. The first is, imagine the secretary said, I'm going to base my determination on the alphabet. And tribes that would begin with the letters A through M get the money. Tribes with M through Z do not. Would we be able to review that?
So I don't think
that's
so.
Yes, that's sort of a yes or no question. You can explain, but I need a yes or no. Is that reviewable or not reviewable?
No, but I don't think that you need to agree with me on that point in order to.
Why no? I understand that you have a fallback position, but why no? Because of kind of for the reasons I was trying to lay out before, because of the way this is focused on the secretary's determination. All right. If that's the case, how do you explain the Supreme Court's decision in Department of Commerce versus New York from last year? That's the census case in which the same argument is made, and the secretary said he had unreviewable decisions about what questions to include in the census. The court says we disagree. To be sure, the section instructs the secretary to, quote, take a decennial census in such form and content as he may determine. Nonetheless, the court said it was reviewable because the census imposes a, quote, duty to conduct a census that is accurate and that fairly accounts for the crucial representational rights that depend on the census. That wasn't even from the statute. That was from a Supreme Court opinion. So there's a case just last year from the United States Supreme Court in which the statute says, as the secretary may determine, and in which the court said that does not resolve the reviewability question. What's your answer to that?
So I think because then we're looking at what is being determined, which is an important thing here. The census count is a kind of independent, objectively ascertainable concept. These increased expenditures are not. It's something that
this went only to the question of what questions could be asked, and the statute said in such form and content as he may determine. But I think the court said that wasn't non-reviewable.
Because I think the subject of what's being determined is relevant, and here what's being determined is something that doesn't exist independently of the secretary's actions.
Well, this does. Why doesn't this? This statute is pretty specific as to the basis. We've been saying increased expenditures, but ... But the rest of the sentence says, based on increased expenditures of each sub-tribal government relative to aggregate expenditures in fiscal year 2019.
I think for two reasons. One, the increased expenditures haven't happened yet.
They haven't, but you could have based it on how much the increased expenditures have happened so far. That would be an objective measure.
Well, and second, there's a kind of circularity to this where the increased expenditures will be influenced by the secretary's actions, so that the amount of money that the secretary provides will influence what the tribes actually spend.
Well, Congress didn't say that. Congress said this is the way you do it, and it gives a pretty objective way to do it. I'm not saying you had to do it that way. I'm not saying you couldn't use a proxy, but the question is it reviewable at all? Let me ask you another question, which Judge Tatel began with in questioning your colleague on the other side, which I don't see how this can be regarded as a lump sum expenditure. This is nothing like what happened in Vigil, where the court says Congress never expressly appropriated funds for the centers that were at issue in the case. That case, it came from a purely annual lump sum appropriation. And the GAO makes clear the difference. Yes, sometimes it's hard to know the difference between a line item and a lump sum, but this isn't a large amount of money that the department can use for whatever it wants and that puts into this thing. This is a specific line item of money that has to be spent for a specific purpose. Why do you regard this as a lump sum?
I think for a few reasons, and I would just like to preface that this is not an argument that we think the tribe actually makes.
I know we heard that in the back and forth between Judge Tatel and your colleagues. So now I just want to ask the question about why you're not asking us to apply the wrong presumption here.
I think it shares some features with the appropriation in lump sum. We have a general instruction of purpose and explicit, in this case, explicit direction to the Secretary to distribute it to kind of possible recipients as the Secretary sees fit. It's also informed by kind of similar policy rationales. The nature of the task requires a considerable amount of judgment. The balance of factors.
That is not the distinction between a lump sum. Judgment is not the distinction. Lump sum is when a large amount of money is given to an agency which can then distribute it to various programs as it wishes. This is only one program. It has to be done for this purpose, no other purpose. Yes, you have discretion as to how to do it for the purpose, but it's not like it can go for a different thing that the department thinks it needs the money for. If this is lump sum, almost everything that is appropriated is lump sum.
So I take your point on the differences. We thought that some of the policy rationales, apply, involving the balancing of factors that are an agency is better situated to do, taking into account kind of what better advances the purposes and priorities.
Where are those factors? In which case, use those factors to determine the difference between a lump sum and a line item?
Well, Lincoln v. Vigil said that these are some of the factors that explain why the lump sum appropriation is unreviewable, and we think that those factors apply here. But ultimately, as this court has emphasized repeatedly, this doesn't move the ball very far in one direction or the other.
So you don't think you get any advantage from calling it a lump sum? I just want to make sure we understand that. So you don't think it's a big deal at all? Presumption isn't much different? The presumption helps, but this court has said that it actually, even if it flips, in the words of this court, it doesn't move the ball very far because judicial review is unavailable regardless of which presumption applies, one of reviewability or non-reviewability, if there are no meaningful standards to cabin an agency's otherwise plenary discretion. And we think that's the case here for reasons I've set out. So whether it falls under Lincoln v. Vigil or something else, that's not dispositive here. I mean, I think it's whether there's kind of a meaningful standard in the statute that is the dispositive question. Okay, thank you.
I don't want to intrude on Judge Garland here, but ordinarily under the APA, there's a presumption of reviewability, correct?
Yes.
So you're saying that it doesn't matter if this is a lump sum appropriation when the Supreme Court and our court has said that there's a presumption of unreviewability with those?
I'm not saying it makes no difference. It's kind of different ways of getting at a similar issue, and ultimately what matters is whether the statute provides a meaningful standard that this court can use to judge. If it does, then either a presumption against a presumption of non-reviewability is rebutted. If there's no standard, no meaningful standard, then a presumption of reviewability is rebutted. So ultimately, what's dispositive is as I said, whether the statute sets out a meaningful standard of review, a reference point that this court can use.
So turning to the facts of this case, why was the population in the IHBG formula area for Shawnee 0?
My understanding, which the counsel for the tribe has confirmed, is it's because the tribe doesn't have a formula area. Formula area as I said, is generally the area that a tribe has jurisdiction over or provides services in. There are many different ways for a tribe to obtain a formula area. The kind of two most common and easily understandable would be if the tribe has a reservation or trust lands that it's responsible for. This tribe does not have a formula area, and the secretary explained when as part of the selection of a population measure, rejected enrollment data because it doesn't distinguish between the population that is within a tribal area and those that are outside. And the secretary was specifically focusing on expenditures related to the public health emergency, such as increased costs for medical and public health needs. And this selection of this measure reflected the belief that tribal governments would be best positioned to make expenditures for emergency-related issues for areas of the tribal where the tribe has jurisdiction and provides services. So that's the connection that was laid out in the appendix.
Do tribes without formula areas have expenditures related to the pandemic?
They might. And the tribe here received funds. It received both an allocation under the population.
That wasn't my question. Do tribes without, first of all, tribes without formula areas have budgets and expenditures, correct?
Yes.
Okay. And are those expenditures related to the pandemic? I mean, did those expenditures go up in 2020 over 2019?
So they could. The secretary explained this a little bit in the May 5th document, that he didn't look just at kind of the 2019 budget and do a mechanical adjustment, because that would capture some things that might be increased expenditures but would not necessarily be appropriate uses of the funds under the CARES Act. The CARES Act sets out certain requirements for the use of funds. And the secretary said specifically he was focusing on expenditures that were due to the public health emergency. And that population was expected to correspond with those types of expenditures, kind of for reasons I've addressed.
Where would I look to find a judgment by the secretary that the distribution of the full allocation of funds to a tribe depends on whether it has or doesn't have a formula area? Because that seems to be the distinction here, right? The tribes that, see if I'm right about this, but this tribe and the amicus and the others that came out to be zero, they are all tribes, presumably don't have formula areas, whereas the tribes, there were, the database, the HUD database, I'm just reading my notes, included some non-eligible tribes and excluded 3 tribes completely, but I assume those were all tribes which the secretary reached out to get accurate data, right? Those were formulas. Those had formulas?
Those 3 tribes did have formula areas. That's what the secretary asked.
That's the distinction that the secretary seems to be making here, right? That money will be distributed under the HUD database to tribes, to the full allotment to tribes that have formula areas, but those without formula areas get $100,000, right?
With respect to the population component of the award,
right.
there were other components that.
Yeah, well taken point. I understand that. So where do we look in the record to find that why the secretary thought that the presence or absence of a formula area was somehow related to the increased expenditures from 2019 to 2020?
So I think there are 2 places. At the appendix 99 to 100, the secretary explains how this population measure is based on formula area, which corresponds broadly to jurisdiction and where the tribe provides services, and incorporates adjustments to address overlapping jurisdictions. And then in the FAQs at appendix 103 and 104, the Secretary talked about how tribal enrollment doesn't distinguish between members living within the tribal area and those living outside the tribal area, whereas formula area does kind of make that distinction. So this reflects the belief that tribes would be kind of better positioned to make expenditures for the public health emergency in the areas where they provide services. The Secretary also identified other reasons why he chose this measure. He said it explained consistent and reliable. It's updated annually using the same census data that Congress required Treasury to use for the allocations to state and local governments. That's the population estimate program, I believe it's called. It's also familiar. This formula was conducted through negotiated rulemakings with tribes.
You read all of that, but I don't think that any of it really answers the question of why it's a fair assumption or it's rational or reasonable to assume that a tribe with no formula area doesn't provide any services.
So I don't think that is, the Secretary certainly didn't take that view. That's why, among other reasons, there's more than one component to the award. There's also an employment component and one that's just tied to actual expenditures that had been incurred by the time the award was made. So this tribe obtained over $500,000 through in that second allotment. I think what the Secretary was, what he explained here was that he was focusing on expenditures due to the public health emergency, that population was expected to correspond to that, and that specifically kind of tribes would be most likely, best positioned to make expenditures for the population living within their area. The statute doesn't create an entitlement to kind of a penny for penny reimbursement of increased expenditures. I mean, that's impossible given the twin kind of goals here of having a fixed amount that he could distribute and a requirement that all the money be given out in a quick period of time, kind of all at once. So this has to be done with an eye towards the whole program. Giving one tribe more necessarily means that the other tribes receive less. So this has to be done by kind of a general formula that works kind of on the whole. There may be, certain tribes that come out better and certain that come out less, but that doesn't make it an unreasonable action, especially in the circumstances we have here.
Judge Wilkins, Judge Garland, any further questions?
No, thank you.
No.
So we'll have to,
Thank you.
thank you.
We've got your argument. Mr. Zucker, I think you had a little time. Not Mr. Zucker. Ms. Thomas. I think you have a few minutes. No, did Ms. Thomas time left?
Ms. Thomas has no
Thank
time left.
Pardon me?
Ms. Thomas has no time left.
Okay, Ms. Thomas, you can take a minute.
Okay, thank you, Your Honor. A couple of points then real quick. First of all, the United
This won't come out of your minute, I promise. But do you agree with Mr. Pullum that the reason your client showed up with zero is because it doesn't have a formula area? That's the reason?
Yes, that's the way yes, Your Honor. That's the way the IHBG program works.
Okay, go ahead.
So a couple of points real quick. First, with respect to the reviewability and the meaningful standards, the United States, the government would have you believe that the only part of the CARES Act that's relevant here is the last half of the sentence. The words that follow, and a determination, as the Secretary shall determine, in order to ensure that the monies are expended. So there's two sets of components here. The first is how much money should tribes get, and the second is making sure that all of the money is distributed. And the government's focused on that last standard of making sure all of the money is distributed. And so this court has rightly pointed out that the first part of the sentence, and as a reminder, this court ruled in the Chehalis versus Mnuchin case, a related case, that it has the ability to review the government's spending decisions here. And so it's already looked at this language, the exact same sentence, the exact same wording, to find that the government's actions here are reviewable. Secondly, with respect to the merits, and I know that the court was asking about the merits, the use of the IHBG formula is obviously in error because it is in error. The data in the formula with respect to the Shawnee Tribe is clear error. It is clearly false. And so to the extent that this court, we believe, can and should look to the merits of the case, certainly in the interest of time and in the interest of judicial economy. And since this court owes no deference to the lower court, it owes no deference to the government's decision. It sits in appellate review of the government's decision. As this court has already pointed out, the relevant facts are already in front of it with respect to the reasonableness.
But if we were to review this, doesn't our review, as you have, pled this case, doesn't it really boil down to whether it was arbitrary and capricious for the government to assign a zero population to those tribes that had no formula area? Isn't that really the question that we would review?
That's the heart of the question, Your Honor. The heart of the question is whether a zero population number, which is obviously false and legally impossible, whether that is textbook arbitrary and capricious and contrary to the law. The law says tribes...
I think that the argument's a little different than that. It's not whether the number is false, it's whether formula area is a adequate proxy for increased expenditures, right?
We think both questions, Your Honor. We challenge the use of the IHBG formula, which uses the formula area, which the tribe doesn't have. And then we challenge the selection of the zero population, notwithstanding, of course, the fact that there's additional data for the federal government. So for the federal government to use obviously false data in its decision is, in fact, textbook arbitrary and capricious. Even if the formula, the selection of IHBG is reasonable, which we don't waive that argument, but even if it is a reasonable formula to use, the purposeful selection of zero population when there was other data available to the government to use it's also arbitrary and capricious. And so we would suggest that this court can, in fact, reach the merits of the case. Again, it owes no deference to the lower court, but if the court decides not to reach the merits of the case, then we certainly ask this court to overturn the lower court's dismissal of our preliminary injunction motion, because we believe we will win on the merits of the case. The government has admitted and the lower court has found that there's irreparable harm. And so for those reasons, we would ask this court to certainly overturn the motion to dismiss, reinstating our claim, to find in favor of the tribe on the merits and awarding the tribe the $12 million that it seeks. Alternatively, if the court does not reach the merits, we ask it to overturn the preliminary injunction motion and remand for further proceedings.
Okay, thank you.
Thank you.
Mr. Combs, thank you both. The case is submitted.
All right, 5-minute break, is it?
Yes, we're going to take a 5-minute recess, right?
This honorable court will now take a brief recess. Attorneys, what it means for you is I am now going to put you in the waiting room. I will bring you back into the courtroom when the judges ask me to. Judges, I will confirm when everybody is in the waiting room.
You have been added to the waiting room. You cannot talk or listen until the host admits you to the meeting.
Court is in session again. Case number 20-1030 et al. DH Lone Point Management LLC petitioner versus National Labor Relations Board. Mr. Delacquille for the petitioner, Mr. Hickson for the respondent.
Good morning, Your Honors, and may it please the Court. I'm Mark Delacquille, arguing on behalf of the petitioner, which I'll call Terranea Resort, after the name of the property. There were three fundamental mistakes in the Board's decision that merit granting the petition for review in this case. The first was the Board's failure to consider significantly similar precedent concerning when kitchen managers constitute 211 supervisors under the National Labor Relations Act. Terranea raised this precedent in its exceptions to the Board, and the Board did not address it at all. Under this Court's decisions, including Brusco Tug and Lemoyne-Owen College, that merits granting the petition. Separate and aside from the Board's failure to consider its precedents, its decision that Mr. Lovato was not a NLRA Section 211 supervisor was unsupported by substantial evidence. And third, the Board's decision that Terranea's discipline of Mr. Lovato was motivated by animus cannot be supported because it is materially based on consideration of imputed animus from the president of Terranea to the actual disciplinary decision makers under circumstances that this Court has held were not appropriate in its Flagstaff decision. Turning to my first argument that the Board ignored its precedents, over the years, the Board has had occasion to consider when kitchen managers constitute 211 supervisors on numerous occasions. Most notably, in the Piccadilly Cafeterias case, the Board determined that an assistant chef and a relief chef constituted 211 supervisors despite the fact that they did not prepare the recipes, they had no input over the menus, and they had no input over work schedules, where those cooks directed their subordinate cooks for a substantial portion of their shifts, even though the head chef frequently exercised overall supervision. And the Board made that decision because it concluded that the preparation, timing, and presentation of dishes and ensuring that those were prepared correctly and appealingly required the exercise of independent judgment. Each of those considerations applies equally to the case at bar. Mr. Lovato was in charge of the kitchen frequently, generally from 8 to 10:30. During that time, he had authority to direct the chefs who worked under his supervision. There's no dispute in this case that Mr. Lovato had the authority to direct those cooks. And as well, he also had responsibilities reorganizing the kitchen, dismissing employees when the workload was insufficient, training, and ensuring that the line was prepared. Under this Court's decisions in Brusco Tug and Lemoyne-Owen, when a party raises a precedent to the Board, and that precedent is significantly similar to the case at bar, the Board is required to discuss it and explain why it's reached a different decision. The Board did not do so at all in this case, and that merits granting the petition. In response to this argument, the Board's primary position was that Piccadilly Cafeterias was outdated in light of the NLRB's subsequent decisions in Oakwood and the Supreme Court's decision in Kentucky River. But that raises a Chenery problem. If the Board believes that Piccadilly, Pioneer Hotel, and the other cases that the employer cited are no longer good law, or that they should be afforded less weight, it should be the Board making that explanation not the general counsel in litigation. Second, and apart from the board's failure to consider whether Mr. Lovato or consider the Piccadilly case and the other applicable precedent about kitchen managers, its decision that Mr. Lovato was not a 211 supervisor is unsupported by substantial evidence. There are three elements that the employer needs to meet in a case like this to show that an employee is a 211 supervisor. The first is that he has the authority to direct subordinate employees. The second is that he exercises independent judgment. And the third is that he may be held accountable for his supervision. In this case, there is no dispute as to the first element. While the chef de cuisine and the sous chef were out of the kitchen, Mr. Lovato, as a junior sous chef, inspected the dishes prepared by subordinate chefs to make sure that they were prepared correctly, prepared in a timely manner, and that if they were incorrect, they were redone. He often acted as an expediter, directing the kitchen in that way. He trained and monitored interns and reorganized the line. The second consideration is independent judgment. And on this ground, the board erred because it found that Mr. Lovato did not exercise independent judgment because he did not make the menu. He did not write the recipes. But in Piccadilly, which I had discussed earlier, that wasn't what the board considered relevant for independent judgment. What the board considered relevant for independent judgment was whether the kitchen manager ensured that the dishes were prepared in a timely, appealing, and proper manner. And that's what Mr. Lovato did. The third prong is the accountability prong, which under Oakwood requires that the employer prove that there is a prospect of adverse consequences for a supervisor's failure to supervise. And this is a classic substantial evidence problem where the record as a whole simply does not support the board's decision. Mr. Lovato's performance reviews in 2011 and 2015, and those are located at JA 540 and JA 532, both noted that Mr. Lovato lacked leadership and needed improvement. Performance reviews for another junior sous chef, Mr. Santos, also graded the junior sous chef on leadership. In May of 2018, within a few months of the alleged...
Excuse me, can I pause? I want to think a little bit more about this Chenery problem that you're talking about. So in Oakwood, didn't the board say that it was establishing a definition for the first time with respect to responsible direction? And didn't it say that with respect to independent judgment? Didn't it say it was changing the definition in response to Kentucky River? And in Brusco, didn't we say that pre-Oakwood cases therefore had limited precedential value?
I'll take all three of those in turn. On the question of responsible direction, it is fair to say that the board established a new precedent, and we believe, for the reasons described earlier, that we met it, and we also believe...
But doesn't that mean that the prior, with respect to the prior cases, they have limited precedential value, and there's no reason for the board to have to say that again, is there?
Well, I think there is a reason, at least under the facts of this case, because there is also the question of what the independent judgment that the board should be considering was. And this gets to the question of independent judgment. In Kentucky River and Oakwood, what happened was the Supreme Court found that the NLRB standard for 211 supervisor status was too stringent, and that some employees who ought to be found to be 211 supervisors were incorrectly found not to be because of the board's categorical carve-out of ordinary professional and technical judgment. So you essentially had too many type 2 errors. In Piccadilly, there was a finding that the employees were statutory supervisors. So as to independent judgment, that error did not infect and could not have infected the Piccadilly decision. And on the question of what independent judgment means for a kitchen manager, whether it means do you write the menu or whether it means do you make sure that dishes are prepared properly, appealingly, and in a timely manner, Piccadilly is on all fours and needed to be considered. Third, turning to Brusco Tug, I believe what the board, or what this court, excuse me, actually said in that case was that the board considered its pre-Oakwood decisions and that it found there that they were of limited precedential value with an explanation. And if that is going to be the outcome in this case, it's something that the board needs to consider on its own. It's not something that the general counsel ought to be raising in litigation.
Does the board have to say it again and again, or isn't it enough to say once?
I think the board does need to say it if there is a significant showing, and that's the test from Lemoyne-Owen, that a pre-Oakwood decision has application to this case. And again, I don't think that we would need to or want to argue for a categorical rule that any time a party finds an arguably applicable pre-Oakwood precedent, that the board has to go and explain yet again, no, Oakwood changed the law. But where there's an aspect of a pre-Oakwood precedent that does appear to be on point, as Piccadilly is on independent judgment, and a party raises it before a board, then I think the onus is on the board to explain why that aspect of the decision was not inconsistent with Oakwood. And in this respect, Oakwood, in its independent judgment discussion, does cite at least one pre-Oakwood decision of the board as correctly stating its position. So it's not as if Oakwood swept away everything that existed before it. And that gets me also to the responsibility to direct prong, which you mentioned. The record evidence is ample that Mr. Lovato had responsibility to direct. I mentioned the 2 performance reviews. I want to mention 2 other items. In May 2018...
Can I just interrupt for 1 second before you go on to that point? I didn't see this Chinnery argument made until your reply brief, as far as well, I guess you made it in your reply brief in response to the board's brief that there's a Chinnery problem here if we accept the general counsel's explanation, but you don't say that there's a Chinnery problem in your opening brief in general with respect to how the board decided this case. I'm just trying to understand your argument here with Piccadilly.
Sure. How it transpired is in our exceptions to the board, we raised Piccadilly on the 211 supervisor status question. The board never mentioned it in its decision, which is the situation that we believe led to Lemoyne-Owen and Brusco Tug problem, and we cited Brusco Tug on this issue in our opening brief. In response, the NLRB said, well, we didn't need to say anything about those decisions because Kentucky River and Oakwood were correctly straight the law, and these were pre-Oakwood decisions. And in response to that, in our reply brief, we said, no, that's a Chinnery problem. If the board believes that Piccadilly no longer accurately states the law or has less precedential value than it used to, then it needs to be the board that says that. And that's where the Chinnery problem came from. If the NLRB's brief was entirely silent on this issue, they would still have the arbitrary and capricious problem for Brusco Tug, but they wouldn't have the Chinnery problem. It's not like the board's decision in this case said, no, Piccadilly is not good law because of Oakwood. The board never said that. The board never even mentioned Piccadilly. So I think it's pretty typical in that respect to raise a Chenery argument in reply.
I see. Okay, I understand you. All right.
And given responsibility to direct, in May 2018, within a few months, and in the same month of one of the allegedly retaliatory disciplinary incidents, Mr. Lovato was put on a performance improvement plan, in part due to his lack of leadership. And in July of 2018, he was counseled and warned of discipline due to his lack of leadership. And this is at JA 397, and it says that the chef de cuisine is writing, quote, to note the disciplinary actions that may transpire from these issues if the behavior continues. She goes on to say, quote, Mr. Lovato's performance has been a cause for concern with the lack of leadership. Quote, Mr. Lovato is lacking any kind of initiative to guide the team in any sort of fashion. Quote, after explaining my expectations, which included Mr. Lovato taking the lead in the station he works, assisting organizing the team, and assisting guiding the interns, this is substantial evidence in support of a finding that there was a prospect of adverse consequences to Mr. Lovato as a result of his failure to supervise. And
is there any evidence of actual consequences for any sous chef being held for junior sous chef being held responsible for the performance of others?
The record indicates that the witnesses were unable to provide on the stand any examples of junior sous chefs being disciplined for failing to show leadership. But
I didn't ask about I'm not sure what showing leadership means. What I'm asking is, although that's yet another point, I'm actually showing being held responsible for what somebody else does.
The witnesses were unable to identify any such discipline. However, I would argue in this case that the absence of evidence is not evidence of absence. And I would also argue that
let me just get the facts right. There are 9 kitchens in the resort, and so at least 9 sous chefs, is that right?
That's right, 1 sous chef kitchen.
And the absence of any time in history for any of those 9 or any of their predecessors or successors to ever being held responsible, that's not evidence of absence?
Not unless it was accompanied by evidence that there was another sous chef who displayed the continued lack of supervision of the line that you've seen with Mr. Lovato. And there was no evidence that there was any other junior sous chef at Terranea who had that same continual failure to supervise subordinate chefs. And I would note...
Sorry, I'm having a question about the continuing failure to supervise. You used the word leadership. Does it say failure to supervise in the forms you're talking about? And does it say, give an example of a failure to supervise?
Well, I would note, if I turn to the counseling memo warning of disciplinary consequences from on JA 397, it says, Mr. Lovato is lacking any kind of initiative to guide the team in any sort of fashion. It also says, we ended the conversation with the hopes that Mr. Lovato will be able to provide leadership, guidance, and quote-unquote supervision to our team at the capacity of a junior sous chef.
But does it hold him accountable for anything that somebody on the team did or didn't do? There was no circumstance like that, was there?
Well, there was the macaroni and cheese incident, and I want to turn to that briefly. I understand that the board found that the discipline was retaliatory. Yeah. However, I don't understand the NLRB to be arguing that no discipline was appropriate for Mr. Lovato when he failed to supervise Mr. Flamenco in preparing what was supposed to be gluten-free macaroni and cheese, and instead sending macaroni and cheese with a roux containing flour to sicken a child. that would be a...
Was it not correct that a week earlier no one had been disciplined for serving a gluten-containing pizza that sent a child to this hospital?
That is correct, but I don't think that the incidences are sufficiently similar, and let me tell you why. What is called the parties the pizza incident in May 19th of 2018 was the first in the record food allergy incident at Terranea. And as a result of that, new procedures and emphasis on food allergies were adopted, including Ms. Guerrero in the in-room dining kitchen, who was the chef de cuisine, going over the standard operating procedures for food allergies at the beginning of every shift. Then 6 days later, on May 25th, 2018, you had the macaroni and cheese incident when the macaroni and cheese that was supposed to be gluten-free went out of the kitchen while Mr. Lovato was in charge, and there's no dispute that he was in charge when that dish went out. Given the close proximity, and I would also direct the court to the emails from that investigation, which are at Joint Appendix 388 to 392, it's very clear that Ms. Guerrero and Mr. Ibarra, who was the head of culinary operations at Terranea as a whole, were concerned about this lack of leadership that let the macaroni and cheese go out. And the chef, or the cook, I'm sorry, who prepared it, Mr. Flamenco, was given a written warning, and Mr. Lovato was given a final written warning. The company has argued because he was the supervisor and that it made sense to put the onus on him, particularly in light of a similar incident in some respects in close proximate time. I understand the NLRB to be arguing that the level of discipline Mr. Lovato received was retaliatory, and I believe the board did find that, and that's what one of the things is being reviewed today. But I don't think that the NLRB has or can argue that it was inappropriate to put consequences on the supervisor who allowed that dish to leave the kitchen when it never should have left the kitchen.
Thank you.
That's a real discipline.
Yeah, so you've just spent a huge amount of time on the mac and cheese incident. And in fact, your blue brief devotes many pages to it. But Lovato was fired after the chicken wings incident. And I didn't see any place in the blue brief where you challenged that until your reply brief. And the board actually argues that you forfeited that.
I think that goes... I didn't mean to interrupt, Judge Tatel.
No, I'm done.
Okay. Well, I think that goes to the procedure of this case. I don't understand the NLRB to be arguing, and perhaps Mr. Hickson will disagree with me, that it was inappropriate to discipline Mr. Lovato for the macaroni and cheese incident in some respect, or to discipline him for the fried chicken incident in another respect, in some respect. I understand the NLRB to be arguing that the ultimate termination was unlawful and that the reason that he was discharged after the fried chicken incident was because there was a final written warning in the macaroni and cheese incident. And so if that final written warning in the macaroni and cheese incident was non-retaliatory, as we contend, that the insubordination at the very least in the fried chicken incident, where Mr. Lovato ignored a direct instruction from Ms. Guerrero to discard chicken that he had rinsed in water, would allow termination.
Do you make this point in the blue brief?
We do. I believe this is made at the very end of the brief. Your Honor, I'm not seeing it right now, but I will get back to you on that.
Okay. Well, you're out of time. Unless Judge Garland or Judge Wilkins, do either of you have any further questions?
No, thank you.
We'll hear from the board. Mr. Hickson.
Good morning, Your Honors. May it please the court, I hope you can hear me well.
My apologies.
I'm sorry, Your Honor.
Never mind. Just go ahead.
Okay. Excuse me, Your Honor.
I apologize for something you didn't even say, so we'll just move on.
Okay. Good morning. May it please the court. Michael Hickson for the NLRB, seeking full enforcement of the board's order in this case. The question before the court is simply whether substantial evidence on the record supports the board's determination that the company failed to prove Mr. Lovato's supervisory status and that it unlawfully disciplined and discharged him because of his prominent and extensive protected activities. This court has consistently recognized that board findings regarding both supervisory status and unlawful motive are entitled to special deference beyond the already high level of deference that substantial evidence review mandates. And here, the record amply supports the board's findings on both questions, and the court should therefore grant enforcement. The discussion so far today, it seems, has focused on the 211 supervisory status issue, so I guess I'll plan to address that first. Go straight to the question about Chenery and the board not expressly addressing Piccadilly cafeterias and some other cases in its decision. I think that the law of this court is clear that when the basis for distinguishing a case is readily apparent, that it is not necessary that the board expressly address that case in its decision. And as we set forth in our brief, the pre-Oakwood, pre-Kentucky River cases that the company relies upon are it is readily apparent that their distinction and how they're not applicable here and would be of only the most limited precedential value because they precede the Supreme Court's decision in Kentucky River and the board's subsequent decision in Oakwood. And there, as was discussed between Judge Garland and my colleague, the Supreme Court and the board made very significant holdings, and the board, guided by the Supreme Court's determination with respect to independent judgment, substantially revised, and changed the standard as to independent judgment. So these pre-Oakwood cases do not apply the controlling legal standard that my opponent agrees is the controlling standard. We know that because not only does the Piccadilly cafeterias, for example, not only does that case precede both Oakwood and Kentucky River, the case actually sets forth no standard of independent judgment. There is nowhere in that decision where any independent judgment standard is identified, and there's frankly no independent judgment analysis to speak of in that case. The judge seems to have simply assumed that these assistant chefs' responsibilities would require independent judgment, but without explaining why, without setting forth any legal standard. The case also fails to recognize, as do all of the cases that our opponent cites, it fails to recognize that the party asserting supervisory status bears the burden of proof, a point that the Supreme Court upheld in Kentucky River, and that since Kentucky River, the board has been very consistent in emphasizing. And furthermore, nothing in that decision, Piccadilly cafeterias, or any of the other decisions contain anything in the way of specific examples. As this court has said, for example, in a Vista Court, a post-Oakwood case, what the statute requires is evidence of actual supervisory authority visibly translated into tangible examples demonstrating the existence of supervisory authority. And the court emphasizes this again, for example, in Matson Terminals. It talks about how there must be specific examples in the record. These pre-Oakwood cases, pre-Kentucky River pre-Oakwood cases that the company cites contain no such discussion of any examples. So there is no Chenery problem. There is no problem. Well, there's just no problem with the pre-Kentucky River cases because it's readily apparent that they're distinct. Again, the court has said this in prior, both the board and the court have made, this court and other courts, including this court in Brusco Tug, the First Circuit in NSTAR, the Fifth Circuit in Entergy, Mississippi, have repeatedly recognized that Kentucky River and Oakwood materially and importantly changed the standard, and that therefore any prior decisions are of limited value. So there's no need for the board to address them here. I would just point out that in Brusco, yes, the board addressed cases there, but first, as Judge Garland raised the question, how many times does the board have to do that over and over again? And secondly, the situation was a bit different there because there the case was actually on remand from this court's 2001 Brusco Tug decision, which was issued prior to Kentucky River. And in the remand, the court asked the board to address these cases, but that remand was issued by the court prior to Kentucky River and Oakwood. So here, the company failed simply to meet its evidentiary burden to prove that Mr. Lovato exercised independent judgment, and also proved that he was failed to prove that he was accountable for other kitchen workers' performance. With respect to independent judgment, you know, I think the company presents the menus and the recipes as if the board made a finding that Mr. Lovato had to exercise some kind of artistic creativity or something. But that's not why the board found the evidence important. It found the evidence important because, as the Supreme Court itself emphasized in Kentucky River and the board in Oakwood, and as subsequent cases have held, if a putative supervisor's discretion is significantly controlled or constrained by pre-established detailed instructions issued by the employer, then that does not show independent judgment. And that's what happened in this case. Mr. Ibarra, for example, testified that the menus and recipes were very comprehensive, thorough, finely tuned, and highly precise standards and instructions. And Mr. Lovato did not have discretion to deviate from those instructions. So in that respect, the company failed to show independent judgment. I did want to address one factual point that was mentioned by my colleague, which is he asserted that Mr. Lovato often acted as an expediter. That is simply not the case. The record shows that it was on very rare occasions, extremely rare occasions, that Mr. Lovato had ever acted as an expediter. The evidence shows that the vast majority of the time, he was simply a member of the line cooking at his station alongside the other cooks on the line, and he was responsible at all times for performing, for preparing, I should say, the dishes that came in on the tickets that were to be prepared at his station. So I would just emphasize, too, that, of course, both independent judgment and responsibility or accountability under the statute, these are both mandatory requirements. So if the court affirms the board on one of them, the court must uphold the board's supervisory determination. We, of course, maintain that substantial evidence supports the board's findings, both on accountability and independent judgment. But I did just want to emphasize that point. With respect to the evidence that the company puts forth on accountability, it claims that Mr. Lovato was subject to eventual discipline based on other cooks' performance. But it's undisputed that apart from the macaroni and cheese incident, which is deficient evidentiarily for its own reasons, that the company had never before in the history of any of its more than 9 kitchens issued any level of discipline, even the lowest possible level of discipline, to any of its junior sous chefs based on another cook's performance or failure to correct another cook's mistake. And more generally, the only evidence that the company put forward was simply too vague, too conflicting, and too conclusory to satisfy its evidentiary standard under the precedents of the board and this court. I'd like to highlight, I guess, that when my colleague was asked about actual discipline and whether there is any evidence of it, there is none except for the macaroni and cheese incident, which I can address if Your Honors would like. But my colleague said that it was that merely that the witnesses on the stand could not on the spot recall an instance. But it's much broader than that, Your Honors. It's that the company walked into the hearing knowing that it was going to assert this defense and that it is its burden to prove this defense that Mr. Lovato was a statutory supervisor under Section 211. So it's not as if the witnesses were caught off guard, and it's not as if the company showed up to the hearing not knowing that Section 211 supervisory status was going to be an issue, it came to the hearing knowing that it was going to put on this defense, that it was its burden to prove the defense, and it came up with nothing in the way of actual discipline. Again, aside from the macaroni and cheese incident. So it's not just the witnesses on the stand, it's the company's overall failure to meet its burden. With respect to the macaroni and cheese incident, it's deficient, number one, because it was discriminatorily motivated. I mean, you can't prove a putative supervisor's 211 status. You can't meet that burden in reliance on discriminatorily motivated adverse action. That's the first reason. And in any event, even setting that reason to the side, the evidence is too conclusory to satisfy the company's burden because it is undisputed that one of the decision makers, Ms. Kwok, she participated in the collective decision to issue discipline against Mr. Lovato, and she understood that Mr. Lovato had directly worked on the dish, not just that he had been present in the kitchen and failed to catch someone else's error, but that he had actually put his hands on that dish. And she understood that that was part of the basis for the discipline. She was one of the three managers who made the collective decision that some discipline would be issued, and she was the person who drafted the disciplinary notice. So in those circumstances, the evidence is too conclusory to satisfy the company's evidentiary burden. The company also mentioned the performance assessments. As the board found, and similar to the performance assessments and evaluations that were addressed by the Sixth Circuit in Frenchtown and by the board in Golden Crest Healthcare, mere negative comments appearing on a performance evaluation are not enough to show more than a speculative risk of material adverse consequences. I mean, in Frenchtown, the evaluations of the nurses in that case used language about leadership and about, quote, supervision. And in Golden Crest, the evaluations addressed by the board evaluated nurses on how well they directed CNAs. And the board and the court, respectively, in those cases, found that those critical comments or comments about areas to improve performance were not enough to show a non-speculative and real risk. And it's true that it need only be a material a prospect of material adverse consequences, but the company must prove that prospect and must prove that it's real and non-speculative and not simply hypothetical. Excuse me. With respect to...
I'm sorry, just so I get this, the JA site that that opposing counsel raised, JA 397, is that what you're talking about, or is it something else? That's the memo to file about, starts by saying, I'm writing this not as a disciplinary notice, but to clarify some concerns, and it discusses leadership. Is that what you're talking about, or something else?
No, well, I wasn't specifically talking about that, Your Honor, although the response is somewhat similar. I was talking about the assessments given to Mr. Lovato in 2011, 2015, and May 2018. The May 2018 assessment, the company calls a performance improvement plan. As the board points out in the footnote in the decision, there's no actual title on the document. Ms. Guerrero did refer to it as a performance improvement plan in her testimony, though she also called it an evaluation. And in any event, regardless of the title applied to that document, it's really not material. Regardless of what you call it, it's just not sufficient.
What about the memo at JA 397 that he was citing?
Sure. That's the July memo memorializing a conversation between Guerrero and Lovato. On that, the board reasonably found that the evidence was just too vague and inconclusive to establish that Mr. Lovato, one, was being disciplined for his own performance as opposed to an error made by another kitchen employee, because that's what the statute requires, as this court has recognized, for example, in the Allied Aviation case. It has to be the putative supervisee's error for which the putative supervisor is being disciplined, not the putative supervisor's own error. And, for example, the memo itself talks about his performance, and Ms. Guerrero, in her testimony about the memo, talks about his performance and his station, referring to Mr. Lovato. And otherwise, the memo, both the memo and Ms. Guerrero, as she was questioned on the stand by counsel, had the opportunity to really flesh out what happened on this night with this, quote, disorganized evening of service. And she just failed to do so. She failed to provide the kind of specific, detailed evidence that the board and the courts require in order to show accountability under that.
It seems like it goes a little bit beyond his own performance. It says it played a role. Freddie is lacking any kind of initiative to guide the team in any sort of fashion.
It does say that, Your Honor, but I would submit respectfully that it's just very vague in terms of what that really means and what happened that night. And, you know, it's just the company's burden to show by specific and detailed evidence. That's what the board and this court require. And, you know, perhaps that could have been fleshed out by Ms. Guerrero on the stand. Instead, when she was questioned and testified, she failed to do so. And so it's both inadequate in terms of establishing that it's his performance versus the performance of others, and it's also inadequate in terms of establishing an actual risk of non-speculative risk of adverse consequences, in that it's akin to the educational in-services that were given to the nurses in Frenchtown. Ms. Guerrero and Mr. Ibarra characterized the conversation as just a coaching or a counseling for Mr. Lovato to learn. And so it's akin to the evidence in that case, which the court held insufficient. I do see I'm over my time, Your Honors, and I'm very happy to answer any and all questions the court may have for me, but I don't want to.
Any other
time.
Judge Garland or Wilkins?
No.
Oh, thank you.
Okay, thank you, sir. Thank you, Mr. Hay. Mr. Delaquill, you were out of time, but you can take 1 minute.
Thank you. First, I'd like to respond to the citation, Judge Tatel, of us making the argument. And I'd switch you to, on page 18, the first sentence of the point 2 in our summary of argument. NLRB's brief, page 58, note 10, which discusses the parties' shared understanding of the relative roles of the macaroni and cheese and the fried chicken incidents. Second, I want to clarify that I intended to state that Mr. Lovato was in charge of the kitchen roughly from 8 to 10:30 every day, not that he expedited for that entire time. If I misspoke, I apologize. And third, I want to address briefly the responsible authority. The NLRB has made much of the inability of our witnesses to come up with an example of similar discipline. But what that really does is attempt to restrict the evidence you can use to prove responsible to direct. The folks who discipline in the Terranea kitchens are cooks. They make food. They're not lawyers. They don't make paper. But they still had noted Mr. Lovato's supervisory failures in his 2011 and 2015 performance reviews, in the May 2018 performance improvement plan, and in the July 2018 memo warning of disciplinary consequences in his leadership. And so...
Mr. Delaquill, you're over your time. Just finish up quickly, please.
I'll stop there, Your Honor. Thank you.
Okay. Thank you. Thank you both. The case is submitted.
Thank you.
Honorable Court is now adjourned until Monday, December 7th at 9:30 a.m.
Goodbye.